13411, Commonwealth v. Dante, S. Padilla.
Okay, Attorney Briggs.
Good morning. May it please the Court, Catherine Briggs on behalf of the Department of Youth Services. This case addresses youth under 18 who are charged with murder. The questions reported by the Superior Court and the amicus solicitation from this court concern only youth under 18 and do not address the status of youth charged with murder who turn 18 during the pendency of their case. This court should find, in accordance with the last paragraph of General Laws, Chapter 119, Section 68, that DYS can have youth under 18 who have been charged with murder and committed to the custody of the sheriff. The courtesy hold process between the county sheriffs and DYS ensures that Massachusetts remains in compliance with federal law, two federal laws, the Juvenile Delinquency Prevention Act, otherwise known as the JJDPA, and the Prison Rape Elimination Act, commonly referred to as PREA. This court should also find that the last paragraph of Section 68 is constitutional. The language in Section 68, and there is nothing unconstitutional about placing a youth in the custody of the sheriff versus DYS. The statute easily survives the facial challenge posed by Mr. Padilla. There is no statutory prohibition to the sheriff's request that DYS hold youth under 18 charged with murder as a courtesy until they turn 18. As custodian, the sheriff has the authority to determine where youths charged with murder are placed.
Can you just to do with this particular defendant? He was a juvenile and then turned 18 while he was in DYS custody.
That's correct. The procedural history of the case, as it will, Mr. Padilla was alleged to have committed murder.
Yeah, no, I understand. So he's in the custody of the sheriff, but
Right,
sitting with DYS,
Right.
and then he turns 18 and wants to stay with DYS.
Correct. And asking that the court order that he remain with DYS. And what that involves is basically they ask the court to change the MIT to say in the custody of DYS versus the sheriff. But the statute.
The context of the case is before he turns 18.
That's correct.
So the only person raising the after 18 issue is the amicus brief of CPCS.
Correct.
Right. The issue before us is just the time period before he turns 18.
That's correct.
But wouldn't we have an issue if we didn't have the courtesy hold? So we don't really have an issue because of the courtesy hold.
That's essentially, Your Honor, yes.
I think
the
you all
courtesy hold-
agree, frankly.
There's not much space between the parties. I
Right,
think this
that's
third question about the constitutionality of the placement in general is what thrusts the case forward. And in that respect, there is between the parties.
It's interesting, I grant that, but not necessary because of the courtesy hold.
In DYS.
My words, not yours.
Right, correct. I mean, yes, the constitutional, there's not much light between the parties, and with respect to the constitutional issue as addressed to youth under 18, no, the courtesy hold process sort of solves this issue that has arisen.
And it solves the statutory issues that aren't before us on the two federal statutes, too.
Correct. Correct, and the courtesy hold process has been in place for a very long time, since 1996 when the law was changed, and when there was a period of time, that's reflected in the record in the affidavit provided by DYS, where there was a little bit of a change in where they were held, and it involved a lot of stakeholders. I mean, this was not a decision that was sort of taken lightly by the parties.
The only thing that really is out there that isn't actually before us is what happens from 18 to 21, which is raised by the Miki, right?
And I mean, the constitutional question was reported, and DYS's position on the constitutional question is that it is constitutional and that you should answer it. In his brief, Mr. Padilla suggested this court should not answer the question of the Constitution because it's too broad and devoid of application to particular facts. To the contrary, the last paragraph of Section 68 is very narrow. It applies only to a small subset of youth, those charged with murder, and it does only one thing. It directs the Superior Court to place in the custody of the sheriff.
It's like 4 to 5 people.
That's correct. It's a very small number for practical purposes, yes. This court must answer the constitutional question because despite the ruling in Nicholas Taylor by this court last year, issues still arrive surrounding the status of youth under 18 charged with murder. Much of Mr. Padilla's argument against the constitutionality of the provision assumes that the plain language of the statute requires youth charged with murder who are under 18 to be housed in adult correctional facilities. This assumption is incorrect. The fact that youth under 18 charged with are ordered into the custody of the sheriff does not mean that they will physically be placed in an adult jail. Youth have never been placed in adult jails under this law. In addition to
normally physical and legal custody. So this is an exception, right? It is an unusual context where we have most of the physical custody being with DYS, even though the legal custody is always with the sheriff, right?
That's correct, and the sheriffs do retain some responsibility to the youth who are placed with us, and they do all the transportation and security when it comes to court dates, medical appointments of that sort. And there is a formal process. You know, the sheriffs do send us a letter. They say in the letter only until they turn 18, and so ostensibly they still retain this power to pull those youth back should they have appropriate facilities for them. In addition to assuming that the statute's plain language means that this cohort of youth will necessarily end up in adult facilities, Mr. Padilla also speculates that these youth will end up in adult jail because the courtesy hold agreements might go away and the federal statutes might not be reauthorized. Facial challenges cannot survive based on speculation unsupported by any evidence. Mr. Padilla does concede, as this court has recognized, that the courtesy hold process comports with constitutional protections and takes issue only with the language of that statute, which places these youth in the custody of the sheriff.
You're not asking us to declare that this would be constitutional absent courtesy holds, right? You're not asking us to go any further than we have to, right?
Violating the federal statute, and you don't want to do that.
Correct. It is these
And
youth.
the other side doesn't really want us to say that you're forced to do something that they don't want to have happen either. So this is kind of as Justice got abstract, but not real world issue.
Correct. Yes, and I think it's important to look at the language of the statute, which again, the statute only says custody, right? In the custody of the sheriff versus DYS, it asks nothing more. So similarly, we would ask this court to also simply just find the language of the statute constitutional.
We can just lecture you and say, keep doing what you're doing.
You're doing a great job.
Yes. The statute easily survives a rational basis test, defeating any argument that it violates substantive due process or equal protection. In deciding that the sheriff would be the appropriate custodian of youth charged with murder for public safety reasons, the same way that they decided that the superior court, rather than the juvenile court, was the more appropriate place to hear the youth's murder cases. This court upheld 119 Section 74 in the Fernandez case, choosing not to question the legislature's judgment. Furthermore, Padilla's argument that the statute violates this cohort of youth's rights free to be free from cruel and unusual punishment relies again on the assumption that the statute somehow mandates these youth to be placed in adult facilities. That is simply not true. Even if the courtesy hold agreements didn't exist, these youth would not necessarily be held alongside adults. The constitutional challenges to the statutes fail when based on assumptions about how it operates in practice.
Well, we don't know whether the sheriffs have separate facilities in every county.
They don't. That's why sort of the process exists, right?
As far as what would happen.
Right. I couldn't speak to what would happen. I can only speak to the fact that when in a situation where the courts are being asked to hold these youth beyond the age of 18, that's when we run into issues of violating federal law. And even brief sort of what else exists in the Massachusetts statutes, which do sort of recognize that there should be a separation between adults and juveniles in terms of post-sentencing and post-adjudication. This court should answer all three reported questions no, confirming that the last paragraph of Section 68 is constitutional. This court should also confirm that the last paragraph of Section 68 does not require juveniles charged with murder to be housed in adult detention facilities, and that the courtesy hold process is lawful. If there are no further questions, the department will rest on its brief.
Thank you. Okay, Attorney Jellison.
And Crystal Morning. Good morning, Chief Justice Budd and Associate Justices, and may it please the court. I think I've heard the word abstract about 3 times at this point, and when I was briefing this case, the justiciability issue was right up front for me. Because of the courtesy holds, the harm that this statute would otherwise direct isn't happening, and I don't think that gives the court a record to decide this case. In some ways, I think it would be an advisory opinion, and I don't think that I could honestly argue that the court should decide this case. Should the court go to the constitutional issue, this paragraph does not meet the rational basis test either under due process or equal protection, and it would present a conditions of confinement issue. And I think
Because technically they're held by the sheriff?
Yeah, well, so this is, what if I were doing.
I get it, because in your
Right.
your first argument's very well stated, but I don't know how the constitutional issue in abstract, because what's happening
Yeah.
isn't what you say the evil
Right.
to be cured is, right?
Right,
Because if there were no courtesy holds, yeah.
Right. So to the extent that Attorney Briggs mentioned, I'm not arguing that courtity holds are illegal
Right.
in any
Yeah.
way, shape, or form.
I would hope not.
Yeah, just to be clear, I'm not arguing that they're illegal. But to the extent that this court has interpreted statutes from this package, from this 1996 package, as requiring children to be treated as adults for all purposes, to me, and Justice Kafker mentioned, custody usually means physical custody too. I really believe this statute does direct children to be held in adult jails, and I'm glad that there has been this workaround. But to the extent that that is what this statute says on its face, I really do think we run into a constitutional problem, and some of that comes from the fact that there really is no legitimate reason to hold an 8th or 9th grader in, it's a rare law that doesn't meet rational basis, but this package of laws was really passed in reaction to the super predator myth, which in many ways was a racist lie. And that we've treated children as adults in some of these other contexts for punishment. Obviously, pretrial detention can't be punishment. For sentencing, I think we all understand that the legislature thought that the sentence of DYS till 21 for a murder was inappropriate. That seems, that's consistent with public safety. If we're looking at whether or not the children are held pretrial, they're certainly being held. Reasons that the court is, and we look at judicial economy, these cases are tried in superior court. Yes, superior court are experts at these cases. Adult jails are not experts at holding children. So there really is no legitimate government reason to put a child.
Doesn't all that not only, but it does suggest that the word custody can't be shared or can't be delegated somehow, right?
Right.
Or that you can't have a difference between physical and legal custody, which none of which we have to decide because sorry.
No, I agree with you. I guess this court could interpret the statute. Fairly from the intent of this package of legislation, I don't know the legislature hasn't acted to change anything that's going on, certainly, and I don't think our legislature today would pass a law saying that you have to put a 14-year-old in adult custody. But the way that the law reads, and it would create great harm to children and serve no purpose. So it really, it represents one of those rare times when the legislature did something in reaction to fear and things that were going on at the time that really didn't have a rational basis. So I guess to the extent that the court wants to decide the issue, I would ask that they not constitutional. To the extent that this is an abstract question because it's not happening, I would ask that you hold that it's not justiciable. And to the extent that there was an amicus announcement about Section 66, I address it. I noticed, I don't think I put this in my brief, so this is why I wanted to say it, that Section 66 uses the word child, and the last paragraph of Section 68 uses the word person. These statutes were changed at the same time in 1996. And it says to me, you know, along with the purpose of the legislature to treat this set of children as adults, that 66 just simply does not apply to this set of children. So I just wanted to note the language
But
that's in the
doesn't-
statutes.
Isn't 66 is the broad statute, and 68 focuses on...
Is the specific.
Yeah,
Yes.
on murder defendants.
Yes,
Right.
yes. If there are no other questions, I would rest on the issues.